We all ready? Okay. Christina Garrison. Christina Garrison, you're charged with domestic battery. The court finds probable cause, bond is set in the amount of $500. No contact with the alleged victim.
Thank you, Your Honor.
Okay, have a good day. Okay, Raina Sedons.
Manjo, Your Honor.
Okay, Raina Sedons, you're charged with aggravated assault with a deadly weapon. You're charged with domestic battery. You're charged with improper exhibition of a firearm. Charged with discharging a firearm in public, and child abuse without great bodily harm. Okay, and who are you, sir?
Her boyfriend, DeAndre Glover.
Okay. And what is your name, sir?
DeAndre Glover. D''Andre Glover.
All right, you're one of the alleged victims?
Yes.
Okay, what do you want to tell me, sir?
I know that the night that it happened, like we were really going through it. Like it was like a small argument.
Okay, there are, excuse me, two other people just came up. Who are you, ma'am?
Her sisters. Her sisters.
Her sister?
Yes. Both of them are sisters.
Okay, and would you state your names for the record?
Maren Sadun. Yusha Sadun.
Okay, and you're the other people that were involved in this?
Yes.
And it was just the three of you, correct?
Yes.
Okay, what else do you want to tell me, sir?
And like I said, like it was a real small argument that turned big. I feel like she was like really stressed at the moment and like really depressed. Like her whole family like is going through something like catastrophic. Like it's different. Like nobody will ever go through it and last how they're lasting.
Okay, are you afraid of the defendant?
No.
Okay.
No.
Are either of you young ladies in fear of her?
No.
Okay, do you feel there's any need for a restraining order or no contact order? Okay. Based upon the probable cause affidavit presented by the state, count one, the court finds no probable cause.
Judge, I have
And,
argument for that count.
Excuse me?
I have argument for that count, Judge.
Please do.
Judge, even though the victims say that they have no fear
Counsel,
of,
stand up so I can see you're talking to the TV.
sorry, Judge. Even though it says that they have no fear, it doesn't matter whether or not they fear. The jury instructions say that if the circumstances were such as to ordinarily induce a well-founded fear in the minds of a reasonable person, then the victim may be found to have been in fear. An actual fear on part of the victim need not be shown.
Okay. But the weapon was never pointed at anybody. It was pointed at the ground. And they all said that they were not in fear of her doing anything. And other than acting out on this, the court finds no probable cause. On count one, the court RORs her on that one. On the battery, domestic, the court finds probable cause, sets bond the amount of $500. On the child abuse without great bodily harm, court finds probable cause, sets bond the amount of $500. Total bond is $1,200. Okay, the court is not entering a no contact order because, believe me, excuse me, I want to do this first. All three of you raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Okay, and sir, you've already stated your name on the record, and you've stated that you are not in fear of the defendant.
No, I'm not.
And ma'am, state your name on the record again. And are you in fear of the defendant? And what's your name, ma'am? Okay, and the three of you were the only people that were involved in this, other than there was a minor child present, correct? Okay,
Can I say something?
yes, sir.
You said there will be a no.
No, I said there is the bond is set in the amount of $1,200. That's all.
And we can't come in within a certain amount of feet of each
No,
other?
no. I did not enter that.
Oh, okay.
Okay? You need to post a $1,200 bond, and she can get out.
Thank you, Your Honor.
Okay. Ashley Smith.
Here at Maine, Your Honor.
Morning, Your Honor.
Okay.
Your Honor, Ms. Smith would like an offer from the state. Alejandro Vargas on behalf of the public defender.
Ms. Smith has counsel here, is that correct?
Yes, Your Honor, she.
And I'm
one
pointing
is-
the counsel to represent her. These are misdemeanors and a municipal ordinance. And Ms. Smith, do you wish to plead no contest to them?
Yes,
Time served. Have a good day, ma'am.
thank you.
Lenina Rosario.
Here at Maine, Your Honor. Ms. Rosario would also like an offer to resolve her case, Judge.
Okay, no problem. Ms. Rosario, you want to plead no contest? Court charged with, you have a capias, $500 bond. Okay, court finds probable cause. Time served. Barbara Garrett, or Garrett?
She's approaching at Maine, Your Honor.
Ma'am, you've got three capiases, bonds are $50 each. Attorneys representing you, do you wish to, go ahead and point it, do you wish to plead no contest, counsel? Pleading no contest?
Ma'am, do you want to plead no contest?
Okay, time served. Christina Morgan.
North Broward, Your Honor.
Christina, got a capias, $100. Do you want to plead no contest? It's on a municipal ordinance.
No contest.
Time served. Charlene Montgomery.
No fraud, Your Honor.
Montgomery, you got two counts. One count's possession of paraphernalia, $100 bond. Then you got a $500 capias on another misdemeanor. Court finds probable cause. You want to plead no contest?
Yes,
Time served. Danielle Coles.
No fraud.
Ms. Coles, you've got two misdemeanor capiases, $500 each, but you got a violation of probation, and so I can't offer you a plea, but the court will argue on counts 1 and 2, and be sure to show up in court. But ma'am, you've got to clear the VOP, and that's set for 7/2. The second, have a good day, ma'am.
Judge, Norma, Ms. Coles, Ms. Coles, I know. Judge, Norma, I wanted to ask, but when it comes to the VOP, I'm asking if you would release her on electronic monitor. Ms. Coles recently lost her son. She was picked up going to work. I'm asking if you could release her on some sort of electronic monitor for her to show up on the date on Tuesday. That's what she asked me to ask the court.
How do I do that, counsel? That's because it's issued by another judge.
All I could do is ask, Judge.
It is difficult, and I really
I
can't.
know.
So, but ma'am, you'll go before the judge on Tuesday morning. Have a good day. Patricia Sieber.
North Broward.
Ma'am, you have 8 capiases. Okay, court finds probable cause. And You want to plead no contest?
Yes, Your Honor.
Okay, the court accepts the no contest plea on all 8 points. Counsel to represent you. Counsel, do you concur in her pleading no contest?
Your Honor, the only thing
Okay, on the municipal ordinances, I understand.
Right.
Okay, court time served, all counts.
Okay.
Okay, Curleen Hilliard.
Remain, Your Honor. She'd like to resolve her case.
Main jail. Main jail.
Main jail? Oh, I'm sorry. Ms. Hilliard, you've got a capias, $500, $250. You want to plead no contest? It's on a paraphernalia charge.
Yes.
Court finds probable cause, time served. Lisa Finelli.
North Broward.
North Broward, Your Honor.
North Broward.
Okay, Ms. Finelli, you're charged with possession of paraphernalia, capias, $250. You want to plead no contest?
Yes, sir.
Time served.
Thank you.
Danielle Deal?
She bonded out, Your Honor.
She bonded, thank you. Then we have Terrence Mullings.
She's here at Maine.
Good morning, Judge.
You're charged with burglary, occupied dwelling unarmed, battery, and criminal mischief. Court finds probable cause all counts. Court sets bond on count 1 in the amount of $2,000, count 2, 500, count 3, 500, no contact, no return. Ma'am, if you post a bond, you can't go back there, don't contact those people. You understand?
Yes, Judge.
Have a good day. Cheryl Yacarno.
Good evening. Good.
What is that?
North Broward. North Broward.
Okay, North Broward. Ma'am, you've got post it? Your bond's been posted, ma'am. You'll be getting out.
Okay, thank you.
Thank you. Nicole Pelletier.
North Broward, Your Honor.
Novell Pelletier, you're charged with attempted felony murder.
Judge, that's
The PC sheet by the police states that the charge is not the correct charge. The court, they claim the correct charge is attempted murder. The court finds that that there's no PC for attempted murder, but there is PC for aggravated battery with a deadly weapon.
Judge, if I can make argument.
Excuse me?
I just want to make argument for the record.
Please do.
And then the state will be relying on the four corners of the affidavit. The detective's intention was to charge it with an attempted first-degree murder, which is it's a first-degree punishable by life. I'm requesting that the court find probable cause on the attempted first-degree murder. This was an argument between the defendant and the victim, where she grabbed the steak knife and stabbed the victim in the chest area. Although the victim sustained a large laceration to the chest area, it caused permanent disfigurement. The victim was transported to North Broward Medical Center for treatment. The victim had an open heart surgery and currently recovering from the stab wound at this time.
But he did not have the open heart surgery as a result of the stab wound.
There's no way I can answer that.
Fine, that's why I can't find probable cause,
Your Honor,
counsel. And the other thing is that there's no indication, where is the indication that she intended to kill him? She used a steak knife and it was I believe the statement was a small laceration.
He stabbed him in the chest, Judge.
Attaining a small laceration, okay? It wasn't even a deep stab wound, okay? So the point I have is Is there anything else in there that indicates she intended to kill him?
Not at this time, Judge.
Okay.
If the court's only finding,
Court is finding probable cause for aggravated battery with a deadly weapon.
Okay.
Here's over there. They'll send you downtown.
Okay.
You close the door.
Court sets bond in the amount of $3,000 and no contact. Have a good day, man.
Judge, I'm gonna ask for, if the court wants more information based on not finding it, I'm gonna ask for 48 hours to perfect the PC. I wanna I wanna get more information from the detective and
The
see.
court sets the bond amount of $3,000, no contact. Said gives 24 hours.
But the bond's in place, correct, Judge?
Judge, if you're gonna be placing a bond that low, I'm at least, and I know that if she places bond, I want the defendant to be aware that she would have to be coming to court tomorrow.
That's not,
For if there's gonna be for a probable cause, if she's released, I'm asking for 24 hours, Judge.
And I have to set bond, counsel. It's a bondable offense.
Then I'm asking for that if you're gonna set bond, I'm asking for a pretrial level 1 with it.
Counsel, I've set bond. You can do what you need to do. You want to file an amendment, you can, and you have 24 hours to do so.
I just want to make clear to Ms. Pelletier and she doesn't need to actually, if she bonds out, she doesn't need to come to court. Eventually what might happen if the state does make a filing decision, then there will be a capias. That would be a different situation. But
Right.
if you bond out today, Ms. Pelletier, you do not need to come to court. No one's ordering
Okay.
you to do that, okay?
All right.
Stephanie Query.
No, Your Honor, she's in the hospital. She's on low.
Okay, medical reset, thank you. Excuse me? She's been okay, she's medical, but she's been bonded. Make sure that's correct, okay. Kelsey Peterson.
North Broward, Your Honor.
Kelsey Peterson, you've got disorderly intoxication, $25 bond, resisting a police officer without violence, or excuse me, with violence. And then you have battery on an officer. Court finds probable cause. Bond is set in the amount of $500 on count 2, $1,000 on count 3. Can you make that bond? No? Pre-trial release. Have a good day. Cecilia Carter.
Come on. North Broward. Oh. Miss Carter refused. North.
What's that? Okay, we'll get her information, pre-trial release still.
And from my understanding, I spoke to her, she's lived here for 2 months.
Okay. Now, Cecily Carter, what about
North
her?
Broward. She refused, Your Honor.
She refused, okay.
Yes. She refused.
Reset. I think she refused last time, too.
Reset, put it on the reset file. It might be in the reset.
Melissa Westbury.
North Broward, Your Honor.
Miss Westbury, you got a violation of probation. The court finds probable cause. You'll be going before Judge Porth on the 2nd of July. Melissa Barlow.
Medical reset.
I have a question. Sir. They told me that I was going, Tuesday of this week to see Judge Merrigat.
Maybe, I don't know, I just saw what they have on the sheet, but you'll be going before one of the judges of the circuit court on Tuesday. Have a good day.
I'm sorry, say that again? Yeah. I didn't hear you. Say it again.
She shouldn't be on the docket? Okay. Delete from the docket. Frankie Langford.
Medical reset, Your Honor.
Okay. Then we have Joel Harris.
Harris, come on. North Broward, he's approaching, Your Honor.
Joel Harris.
Mr. Harris, you got domestic violence, court finds probable cause, bound and set in the amount of $1,500, no contact with the alleged victim. Darius King.
He's here at Maine, Your Honor.
Mr. King, you're charged with domestic battery. The court finds probable cause. And who are you, ma'am?
Natasha King.
Step out here, ma'am, so I can see you. Okay. Who are you?
His girlfriend.
Okay.
King.
And, okay, this is, you're the alleged victim in this, ma'am?
Yeah.
Raise your right hand, swear to tell the truth, the whole truth, nothing but the truth, so help you God. Okay. What do you want to tell me?
He didn't hit me. I lied.
Okay. Are you afraid of him?
No, I am not.
Do you want the court to not enter a restraining order?
Correct.
Ma'am, one thing disturbs me is that the two children, 3 and 4, corroborate the story that he hit you, or that
But
there
he
was
did, and they were in the room.
a.
We was just arguing like couples do.
Okay. All right. The court is going to set bond in the amount of $500. It's not going to enter a no-contact order based upon the testimony of the alleged victim. Have a good day, ma'am. Waldo Alonzo.
He's approaching at Maine, Your Honor.
You're charged with battery on a person over the age of 65. Court finds probable cause, and the bond is set in the amount of $1,000. No contact with the alleged victim.
Your Honor, if I may, we're going to be asking the court to consider releasing Mr. Alonzo on standard pretrial release. He's presently unable to post any bond. He's unemployed, Judge. It's my understanding this might be some domestic issue in nature.
It's definitely domestic, okay? And the court sets bond the amount of $1,000, and now that the court is not considering pretrial release at this time. Then we have Luxon Cherry. You're charged with domestic battery by strangulation. The court finds probable cause. Bond is set in the amount of $1,500. No contact with the alleged victim.
Your Honor, Mr. Cherry have an order to access his property to obtain.
Granted.
Thank you.
Leonard McKenzie.
Judge, we're
Yes,
asking,
sir. Go
Mr.
ahead.
McKenzie has been attempting to retain private counsel. It's my understanding that we could reset this to Monday because it doesn't look like anybody's there.
Who's your private counsel,
Your Honor, I talked to my family member. They supposed to came today. I guess they don't have them, so I'm just gonna reset it Monday, and we'll go from there. I don't know who they're hiring yet.
All right, so you're asking me to reset this to allow your family to provide an attorney for you and to appear here on Monday, is that correct?
Yes, sir.
Do you understand you'll be detained, because presently there are no bond holds on you and you'll be detained until Monday on those holds?
Yes, sir.
Okay, reset to Monday. Any objections, State?
No objection.
No, Judge.
Page 12 now.
Tyler Creamer.
It's approaching in Maine, Your Honor.
More than that.
Mr. Kramer, you're charged with domestic battery, court finds probable cause. You're also charged with tampering or with or fabricating evidence, physical evidence. Both court finds probable cause to both counts. Bonds are set in the amount of $1,000 each. No contact with the alleged victim. Have a good day, sir.
Your Honor, we're going to be requesting standard pretrial. The alleged victim does not live with Mr. Creamer. Any harmful contact would not be an issue. He does work part-time with his family down here, so he is a shared parental obligation with his children. He needs to be out. He's presently unable to post a bond.
Pretrial release is not granted at this time. Have a good
Can he have
day,
an
sir.
order?
Turan Smith,
Your Honor, can I have an order to access property on Mr. Creamer?
you may.
To obtain phone number. Thank you. Mr. Smith is approaching.
Mr. Smith charged with aggravated battery on a pregnant woman, or actually aggravated battery because you allegedly struck a pregnant woman. Court finds probable cause, bond set in the amount of $1,000. You have a capias on a traffic matter of $50. Court finds probable cause, total bond $1,050. No contact with the alleged victim.
Judge,
Count two, I have 500.
500 is the KPS amount.
Is it 500?
Yes.
But you know what? The fine is say 50.
The paper says 50.
Right, 50, but let me look at the KPS. The docket says 500 and the KPS says 50. So 50, yeah.
It's 50.
Then it's 50, Judge.
Yeah,
If that's what
50.
the KPS says, then it's 50.
Chris Banks. Mr. Banks, you got a violation of probation. No bond hold. You'll be detained going before Judge Al Spector on the 2nd of July.
Thank you.
Darius Woodson. He bonded? He's good. He's got 4 or 5 felony VOPs. Delete. Franklin McCoy. Franklin McCoy, you got an open container violation. Counsel you on this?
Yes, we were.
Okay, you're so appointed. What do you want to do?
He wanted to resolve.
I'd rather resolve it.
You want to plead no contest? No contest. Have a good
Yes,
day.
sir. No
Time
contest.
served.
Thank you, Judge.
Thank you.
Wilhelm Mark.
He's approaching your main, Your Honor. Mr. Mark would like to resolve his case.
Your Honor, he's also on pre-trial for another.
What's he got on the
Petty theft. Prior conviction.
Mr. Mark, you got two cases. You got a loitering and prowling, which I find probable cause, bond is set in the amount of $25, and you have a petty theft. You want to plead no contest to both of them?
Yes.
Time served. Counsel, how do you, excuse me, how do we do this so she has the proper paperwork?
Well, since that's a revocation and you're.
Should I give her this and then she give it back to you?
No,
You want the case number? 19006598 MM10A. Okay.
oh, you don't have to sign. Oh, that works too.
Damian Johnson.
He's approaching at me.
Mr. Johnson, you're charged with possession of cannabis. It's a $500 capias. Do you want to plead no contest?
Yes.
Withhold. Have a good day. Sergio Texeria de Olivia.
Judge, we need a Spanish interpreter for this case.
We got the Spanish interpreter. Madam Interpreter, you swear to interpret from English to Spanish to English as best you can?
I do. Maria
Thank you. All right, Mr. Oliveria, you're charged with
Señor
DUI.
Oliveira, se le acusa de manejar bajo la influencia de alcohol o drogas.
Where it has a $500 bond,
Lleva una fianza de $500.
and then you have some traffic citations, which bonds are not required.
Usted tiene también tickets de tránsito donde no se requiere fianza.
Court finds probable
La Corte
cause.
encuentra causa probable para el delito.
Can you make the $500 bond?
Usted puede pagar esos $500 de fianza, los puede pagar.
Yo normalmente, ¿cuánto tiempo le plazo la fianza para pagar? ¿Tengo plazo de cuánto tiempo?
How much time do you give me to pay the bond?
You sure?
Sir,
Don't think.
can you make the bond within the next day?
Usted puede pagar esa fianza entre hoy y mañana. ¿Puede pagar la fianza? No. No.
Pre-trial release.
Le están dando la libertad anterior al juicio con un programa,
Special condition, no alcohol or intoxicants.
con la condición especial que usted no use drogas o alcohol.
Johnny Lewis.
He's approaching at me, Your Honor.
Mr. Lewis, you're charged with DUI, $500 bond, court finds probable cause. Can you make the $500 bond?
I don't have it now.
Talk to him.
I don't have it now. I can't pay back.
Pre-trial release, no alcohol or intoxicants during the period of release. Vestin Madre,
North Broward, Your Honor.
Hello, good morning, Judge.
Sir, you're charged with DUI, find probable cause, bond is set in the amount of $500. Can you make the bond?
No, I cannot.
Pre-trial release, special condition, no alcohol or intoxicant. Crucell, Herbie Crucell,
He's here to remain, Your Honor.
you're charged with you got a capias, $1,500, court finds probable cause.
Hey, yo.
This is charged as a misdemeanor. Sir, you may have priors, this could go to the next one where it would be a felony. But if you want to plead no contest, I'll take the plea.
I would like to.
Time served. Have a good day. Harold Mazzarino.
He's here, man, Your Honor.
Harold Mazzarino, you're charged with 2 violation of probations. You have no bond hold. You'll be taken before Judge Evans on the 2nd of July. Richard Azor.
He's approaching here at Maine. Mr. Azor would like to resolve his case, Your Honor.
You're charged with resisting without violence. Court finds probable cause. $250 bond. You want to plead no contest?
Yes, Your Honor.
Time served. Daryl Tabor.
He's approaching at Maine, Your Honor. Mr. Tabor would like to resolve his case.
Mr. Tabor. You're charged with petty theft. Court finds probable cause. Bond is $1,000. You want to plead no contest?
Yes, sir.
Okay, court finds time served. Have a good day. Ricardo Canero.
He's approaching at Maine.
State, I don't have any probable cause affidavit on these in-state arrests and the municipal ordinances with the computer, go ahead. Oh, Counselor, you're representing them?
Only as to the municipal ordinances, not as to count 4.
What do you want to do, Counsel?
Well, I'm not certain about count 4. I don't want, I know it's a
Okay.
civil out of county hold, but I wouldn't want him to resolve and then
All right,
affect
let
him
me
in
explain
some
the
way.
problem. I can't hear because of the
Can you
the
guys
noise
turn off
in the
the
jail.
mic?
Okay, now, what do you want to do, Counsel?
No, I'm, it's only one municipal city ordinance case with 3 charges, but I'm not certain about count 4.
Count 4, we can't do anything with it, it's an out-of-county hold.
Right,
If
and
we
it says
plea
it's
out
civil,
the
but-
3, if we plea out the 3 capiouses, then
He might-
the out-of-county hold, he'll have to deal with, but
Transfer
they'll
court.
transport him to that county if the county will pick him up.
Right, do you understand that?
You want to do that?
Yes.
Okay.
Does anybody have a PC sheet on this? On these charges?
No,
Because what I'm reading it as is he's failed to provide proof that the animal was inoculated, had its rabies shots. Anybody know? Can't find anything.
Give us
The
one-
municipal ordinances, and it's $100, which indicates they,
What are you looking
the
for?
dog was, whatever the animal was not being abused.
Right, the NTA?
Huh?
You wanna know what the notice to appear says? It was a notice to appear.
Could I see that?
It's on my phone, but I can read it.
Do you have it? Can I read it off yours?
We found the,
Okay, I think he's gonna print it for you.
yeah, that's what we're printing right now.
Failure to provide humane conditions for a pit bull.
Hmm.
Just for something else.
No, I'm not gonna offer him a plea on this.
And it's also a 2016 case, so it's possible that he should fight it anyway. It's in the time frame. But I just don't know if it will keep him, if we could do something with the bond so they have to clear the bonds out of.
Let me say this. If the city is able to prove the charge as contained in the notice to appear, the court would not be inclined to change the bonds. The court feels the bonds extremely low because this is repetitive abuse of an animal, and he had been warned on prior occasions. So the court declines to offer him a plea. His bond is, total bonds are $1,800 because it's a $1,500 one from out of state or out of county. Have a good day. All right, Michael Moore.
North Broward, Your Honor.
Michael Moore charged with possession of cannabis. You have a $500 capias. You want to plead no contest?
No contest.
Withhold. Roger Tony.
He's here in Maine, Your Honor. He'd like to resolve his case.
You're charged with petty theft. There's a capias, $500 bond. You want to plead no contest?
Yes.
Time served. Emmanuel Verder.
He's also here in Maine, Your Honor. He'd also like to resolve his case.
Okay. Mr. Verder, you've got an off-lawful tag, $250. You want to plead no contest?
Yes.
Time served. Zoltan Zabo.
He's approaching in Maine, Your Honor.
Counsel, you representing him?
Yes, Your Honor, it's hard. City Hall.
Sir, do you have two capiases, one for urinating in public, the other for open container? You want to plead no contest?
Yes, sir.
Time served. Jordan Emmerich. Mr. Emmerich, you're charged with DUI, alcohol. Court finds probable cause, $500 bond. Can you make the $500 bond?
No.
Pretrial release. No alcohol or intoxicants while on release. J.W. White.
He's here, Your Honor. He'd like to resolve his case.
Mr. White, you're charged with expired DL. You want to plead no contest?
No contest, sir.
Court finds probable cause. Time served. Brandon Tiano?
He's here in Maine, Your Honor.
You're charged with DUI, with property damage, $1,000, DUI, $500. Then you have two charges, no bonds are required on because they're traffic citation. Bond is $1,500. Court finds probable cause. Can you make the $1,500 bond?
Yes. Yes.
Okay, post bond. Get out. Okay, Walter Papelzarchik.
He bonded out, Your Honor.
Okay. Tony, Mario Tozzi.
Ponzi, yeah.
North Broward, Your Honor.
Counsel, you're representing Mr. Tazi. Mr. Tazi, you got an open container, $100 bond. You want to plead no contest?
Sir, you talked about that thing in 2010. I saw a judge about that, and they were all wrong. Wait, let me explain. The police.
You don't have to talk about the facts of the case, Mr. Tazi.
I was sitting at a
Sure,
Mr.
sure,
This is way
sure.
back in 2010. When I went to, I was innocent. I didn't pull anything out of the garbage or drink any beer. Two policemen arrested me. And I went into court with my mother, and she knew I was telling the truth, that I didn't touch no beer out of a garbage can. I was sitting there with two police came behind a residence of some sort. But she never paid the court cost.
Sir.
She never paid the court cost on it.
Sir.
And that's why they have it.
Fine, okay, then we're here. You got a capias for $100. Do you want to plead no contest to not paying the court costs?
I'll do it.
Okay. Would you, yes or no, sir?
What do you say?
That you're claiming you didn't pay the court costs, right?
Oh, my mother did. My mother was present there, and she didn't pay the court costs. No, she didn't.
Right.
That was
Okay.
over 10 years ago.
All right. Time served.
Okay, sir.
Thank you. Valentino Gonzalez.
The main judge.
Okay, sir, you're charged with, you got a capias for DUI and a capias for a second DUI and operating without a valid driver's license. There are 2 no bond holds. You'll be detained going before the judge who issued those holds. On the second, the count 3 is a $100 bond, but you basically wait till you go to court on the others. Dennis Brown. Court finds probable cause. Mr. Brown, you got a capias.
No, it looks like it's a misdemeanor if the court has an offer.
Yeah, this is I understand. I was just looking for what the charge was. You're charged, sir, with possession of cannabis. You want to plead no contest?
Yes, sir.
Withhold.
Contest.
Withhold. William Ellerby.
North Road, Your Honor.
Counsel, you representing him?
Yes, we've already been appointed, Judge.
Okay, Mr. Ellerby, this looks like an ad charge. Do you want to plead him out anyway?
I believe that's up to him.
Okay, Mr. Ellerby, this is an ad charge, and it's possession of a controlled substance. I don't know what the other charges are.
I could tell you, Your Honor. He's being held no bond regardless of what we do today to robbery, firearm, and an aggravated
Okay,
claim.
then, we're not gonna, you got a $100 bond on this one. Have a good day.
Thank you, Judge.
Brian Trella?
North Road, Your Honor. He's in a wheelchair. He's approaching.
This is another ad charge, disorderly intoxication.
This one, he actually had time served on count 1. I think they put him out.
They figured
missed
they
this
got
one.
to do it. Okay, you got a capias that they, disorderly intox. Do you want to plead no contest?
Mike Jones.
Yes, sir.
Time served. Have a good day. Cedric Greer.
He's on loan, Your Honor.
Cedric Greer, he's on medical loan? Okay. Michael Jones.
North Broward, Your Honor.
It's in the recent.
Mr. Jones, you got a trespass probable cause, 250 bond. You want to plead no contest?
Yes, sir.
Time served. Yes? Victor Coradolcio, Coronata,
Here, Maine, Your Honor.
yep. All right, charged with possession of cannabis, over 20 grams, $1,000 bond, possession of paraphernalia. Sir, can you make the $1,000 bond?
Yes.
Okay, post 1,000 and you're out. Joseph Vermol,
North Broward, Eagle Medical Reset.
okay. Stephen Sykes. Oh, I got stuck together.
Here, Maine, Your Honor.
Mr. Sykes, you've got, let me see here. You got 25 counts. Okay. Counts 1 through 21 or actually through 20 through 21, I'm sorry. Our felony, 20, counts 1 through 20, are felony no bond capiases issued by the judge to whom is assigned to the case. And you'll be detained going before the judge on July 8th. Then you have a capias, which is no bond for traffic. And then you have aggravated assault with a deadly weapon, counts 22, 23, 24. And 25 is grand theft, $1,000 bond. State on the aggravated assault with a deadly weapon. Anything you want to?
Just one moment, Your Honor. Are you asking for a bond amount, Your Honor?
Yeah, he assaulted all these people at the same time.
Yes, he did, Judge. He said,
Okay,
if you come near me, I will stab you, and I have a gun, and he started reaching into his waistband.
I got it. Mhm. Okay. Court sets bond the amount of $3,000 each count. And no contact with the alleged victims. Okay, you'll be detained going before the judge on the 8th. Have a good day. Kelly Figueroa.
North Broward.
Okay, Mr. Figueroa, you've got, 8 felony capiases, no bond. Then you have a burglary, occupied dwelling unarmed. Court sets bond the amount of $5,000. Then you have grand theft, 1,000, illegal use of credit card, 1,000, burglary of an occupied dwelling unarmed, 5,000. And then you have grand theft, 1,000, fraud, uttering a fraud system at 1,000. You have loitering and prowling 25, and resisting an officer without violence 100. Court finds probable cause, all counts. You'll be detained going before the court on July 2nd. Have a good day, sir. Okay, Michael Rich.
He's at main, Your Honor.
Mr. Rich, you're charged with murder, premeditated, no bond. You're charged with possession of a weapon or ammo by a convicted felon, no bond. Court finds probable cause, all counts.
And the state would be requesting that you find proof evident presumption great, and the state would be relying on the affidavit that the court had in front of it, Your Honor.
Your Honor, when it comes to count 2, he is entitled to bond on count 2. That's not a PBL, so we do have to set bond as to count 2. As for count 1, having read the probable cause affidavit, there was a number of events that apparently took place, that there was a stolen purse and then there was some sort of confrontation. According to the alleged victim themselves, they swung at Mr. Rich. They say they swung actually a few times at Mr. Rich. And then it was after that then the victim says Mr. Rich allegedly took out a gun and shot the victim, but that the victim was the one who was swinging at Mr. Rich first. Given the fact that there was a confrontation, it was verbal, and then the victim is the one who took the first punch, even if the victim says they missed, it was the victim who aggravated the scene. Because of that, in the charge that the state has brought here, which is attempted premeditated murder, I don't know if that's going to be the proper charge going forward. I don't know, based on those facts, if there's proof evident presumption great, given that the victim admits they swung at Mr. Rich first.
But there was a break in time, counsel, and he returned on his bike and shot him. And that's where, and he said, I told you I was going to get you, or something of that nature. So I would, while I think your argument is well made and should be brought before the court, I think the presumption is great and the proof is evident. And the court, no bonds on count 1. Court sets bond, because you're correct, it should be set on count 2. Court sets bond $5,000 on count 2.
I have no victim contact, Your Honor.
Well, excuse me, I believe the victim is deceased.
I mean,
it was attempted, Judge.
Attempted murder.
Attempted.
Oh, attempted, okay.
Yeah, please don't.
Right, no contact.
Well, right, but also just then make your finding, please, to attempted murder, not murder.
Okay. Have a good day. Paul Acevedo. Paul Acevedo, you're charged with possession of marijuana, possession of methamphetamine, and resisting a police officer without violence. $1,000 bond. Court finds probable cause. Can you make the $1,000 bond? Sir, can you make the $1,000 bond? Sir, I asked you a question.
Yes, sir.
Can you make the $1,000 bond?
I have cash only. That's why I have no card to. I have only cash. Sir, I have money. I have a $14,000 check because I just settled my settlement.
Sir,
I paid, but only cash. I didn't get my card.
Then you can make any telephone call you need. You may postpone. I'll give him a call order. Okay, thank you. Michael Jones. I got Michael Jones. It was out of order for some reason. Do we have Michael Jones? Anybody got Michael Jones? So he shouldn't be on the
No,
docket?
that was the one I passed back to you to sign. You time served. You just didn't
Oh,
sign it.
okay, I'm sorry. It wasn't signed, that was all? All right.
You time served.
Okay, next we have Alexander Gonzalez.
He's here, man, Your Honor.
Okay. Does anybody know whether these capuses are for no-shows or whether he's on probation or something? Okay, very good. Thank you very much. Okay, Mr. Gonzalez, you've got a domestic battery on a person that you should have known was pregnant. Court finds probable cause. You have two misdemeanors. Okay, one is possession of cannabis, the other one is possession of a prescription. Drug without a prescription label. Now, as to counts 2 and 3, which are the marijuana and the pill, do you want to plead no contest?
Yes.
Okay, time served. Excuse me, not time, withhold in court cost on the marijuana, and withhold on the count 2. Now, on the battery charge, the court sets bond the amount of $500 and no contact with the alleged victim.
Okay. Thank you.
Okay, then we have Eddie Milner. See what I mean, counsel? You're charged petty theft, resisting the recovery of property, and you have a VOP felony warrant for $2,500. The court finds probable cause, all counts. Do we need to post a bond, set a bond on count 1? No bonds required. Okay, sir, you got $2,600 in bond. Court finds probable cause. Have a good day. Tickeray Brown.
North Broward, Your Honor.
Mr. Brown is a medical reset, Your Honor.
Okay.
You hear that?
Aristo Elzika.
Kaya is approaching at Maine, Your Honor.
Mr. Aristo? Is that you?
Yes, Your Honor.
Okay. You're charged with grand theft, $1,000 bond, resisting an officer, $100 bond, driving a license suspended, $100 bond, and fleeing and eluding, $2,500 bond. Court finds probable cause, all counts, and total bond is $2,000. $3,600.
Your Honor, one
$700.
moment. He's currently on pretrial for robbery by sudden snatching no weapon.
Oh,
Case
my
number
gracious.
1701385 CF10A. We're asking that you revoke his pretrial.
Okay, pretrial release is revoked, and bond is set in the amount of $5,000. Have a good day, sir. Gregory Bagundi? Bagundi.
Here, man.
You charge, sir, with driving under the influence, $500 bond. You got a violation of felony probation, no bond hold. You'll be detained going before Judge Coleman on the 2nd of July. Bond on the DUI is $500. Robert Doherty.
Judge, we'll waive formal reading of the charges. I'll just ask my colleagues to explain that.
He's approaching here, man, Your Honor.
Robert Doherty, you're charged, the attorney has waived the formal reading of the arrest document. The court finds probable cause all counts.
Your Honor, on count.
There'll be no contact with the alleged victims. The court appoints the guardian ad litem to represent the minor interest of the children. Go ahead.
Based on on the charge, Your Honor, and based on the probable cause affidavit, the state will be relying on the probable cause affidavit, the four corners of the probable cause affidavit, and be requesting that the court find proof evident presumption great and hold the defendant no bond on count 1, count 2, count 3, count 4, and I think this on those counts, Your Honor. Well, he'll be held no bond.
Okay, what about
On all counts, Your Honor. On all counts.
Huh?
I'm asking that the court find proof evident presumption great.
I understand that. That's count 1, 2, 3, 4.
Yes.
What about the counts 5, 6, 7?
As a bond recommendation, Your Honor, I'm asking for each count to be on $250,000 on each count, Your Honor.
On what basis?
The facts are egregious, Your Honor.
You're asking for a no bond, proof evident presumption great on.
He's entitled to a bond
And he's
amount.
entitled to bond on the other. My question is. Never mind.
And my
Defense, you wish to say anything?
Judge, I have no objection to the no bond hold on 1 through 4. At magistrates will reserve argumentation for division. We're going to invoke his right to silence today, just for the record. As for counts 5, 6, and 7, he is entitled to bond. He's going to be held no bond on counts 1 through 4. I'd ask for $10,000 on each count.
Okay. Thank you. The court finds the proof is evident, presumptions great as to counts 1, 2, 3, 4. And those will be no bond holds. As to counts 5, 6, and 7, the court sets bond in the amount of $25,000 each count.
And you ordered no victim contact, correct, Your Honor?
I've already ordered no victim contact. I've also ordered a guardian ad litem appointed. Okay. Then we have William Washington.
He's here at Maine, Your Honor.
Mr. Washington, you're charged with possession of Oxycontin. Court finds probable cause, $1,000 bond. Then you have trafficking in Vicodin and hydrocortisone and Oxycontin and morphone, I guess it is. And on counts 2, 3, 4, and 5, bond is set in the amount of $250,000 each count. So it's 1,000, 250, 250, 250, 250. Court finds probable cause, all
Your Honor,
counts.
there's also special bond conditions that the defendant needs to be made aware of if he's posted bond. Does the court have the rest of the order setting bond by Judge Rubolo?
I believe that this was order setting bond, and the court is entering or all of the conditions set forth by Judge Robalo in the order setting bond.
Thank you, Your Honor. So, sign it.
Lewinsky, Musil,
He's approaching at Main, Your Honor.
this one is, you're charged with murder, premeditated. The court finds probable cause, finds the proof evident, presumption great, and bond, there is a no bond hold. You'll be detained on a no bond hold until you go before the judge to whom it's assigned.
Judge, I'm assuming the state's going to ask for the proof evident presumption great finding. I'm going to object to that finding today after reading the probable cause affidavit. So I have two main arguments that I would make here. One, it's a little hard to read and understand exactly the actions that took place. So I'm going to explain it, at least how I see it, that Mr. Mukiel was sitting in the car, and the alleged victim, it sounds like he kind of like leaned in through the driver's side and slapped at Mr. Musical and then ran around the car to where he was sitting. At that point, there was some sort of interaction. The other person in the car did not say, or actually did say that he did not see a gun prior to this incident. He then heard a gunshot. The alleged victim is the one who was shot at that point after hitting Mr. Musical and then running around to where Mr. Musical was sitting. I don't know where we see premeditation in that, since according to everybody here, it was the alleged victim who actually did start this one. You know, we have two witnesses who say it. I understand the witnesses say it seemed like it was a joking slap, but it was still an altercation. And then allegedly, the alleged victim ran around the car to get closer to Mr. Musical. I don't see premeditation on Mr. Musical's part with that. And then beyond that, I think there could be good grounds here for some sort of self-defense argument. As Mr. Musical was sitting in the passenger seat of the car, another individual reached through, slapped him, and then came around the car and approached him while he was still sitting in the car. And so because of that, I don't believe there's proof evident presumption great as to premeditated murder.
The court takes notice of the defense's argument, and the court finds the proof evidence presumption great, no bond. Have a good day. Okay, Marcus Gongalves.
Judge, we'll wait
He's
for
approaching
formal
in
reading
Maine,
of the charges. We'll wait formal reading of the charges, just so Your Honor knows, it's a third-degree felony, it's a bondable offense.
All right, sir, your Marcus Gongalves, you're charged, the defense, your attorney is waiving the reading. The court finds probable cause. The problem, this is by a warrant or by a capias.
Well, right, it's a no bond hold for magistrate, so he did not have a convenience bond, but so this is his magistrate date. He's never appeared before this, on this case before.
Okay, state anything you want to?
Can we have a moment, Judge?
Judge, in terms of the bond amount, we would be asking for $35,000.
Excuse me?
$35,000.
Okay. Court finds probable cause, bond is set in the amount of $5,000. Have a good day, sir. Keanne Johnson.
He's approaching at Main Yard.
Ms. Johnson, you're charged with robbery. Court finds probable cause and grand theft. On the grand theft charge, bond set in the amount of $10,000. State?
Your Honor, I'm asking that the court hold the defendant no bond and find proof evident presumption great based on the four corners of the affidavit. On the four corners of the affidavit, this was a. Oh yeah, yes, I remember this. This was the incident that occurred that was caught on surveillance, Your Honor. Based on that information and the four corners of the affidavit, I'm asking you hold the defendant no bond and no victim contact, Your Honor, and find proof evident presumption great.
And Judge, I'm going to object to the finding of proof and presumption grade as terms of identification. So as the state says, this was caught on tape. So the officers, what they did here is they took the tape and they found a photo of Mr. Johnson. They went to the victim. They asked the victim, is Mr. Johnson in this photo the person who committed the robbery? The victim said they could not make the identification based on the photo. What the victim then said is, well, if they saw the person, if they did a show up in person, they think they can make an identification, but they never made an identification of Mr. Johnson. Instead, what the officer did, which is strange to me, he found another officer who was not part of this investigation at all, showed the surveillance photo to the third officer and a photo of Mr. Johnson, and that officer said, yeah, you know what, those two look the same. To me, there's no good identification here, definitely not identification that rises to proof and presumption grade. I have no idea why, when the officers detained Mr. Johnson, they just didn't do the show up with the victim at that point. If the victim says they can make the identification in person, why not do the show up, and then you have the victim who can make the identification, not some third-party officer who had nothing to do with this. Because of that, I do not think we have good identification, and so I'm objecting to proof and presumption grade.
State?
Your Honor, we don't. Another person can identify a defendant or a suspect in a video. It does not have to be a victim. It's someone that has either prior interactions with the person or knows the person personally. In this case, Officer Gelletsberger was able to identify him based on the surveillance, based on the identification that we have. There is enough for the court to find proof evident presumption great and to hold the defendant no bond.
Okay.
I would also tell Your Honor, the state and
The
officer.
the witness says, I think I can identify him, I see him in person. I can't identify the person on the video. Correct? And they're saying they can't identify the person on the video as the perpetrator.
The officer showed a
Wait a
photo
minute,
of
just a
Mr.
second, just a second. Is that correct, State?
He says that he was unable to identify the suspect from a photo lineup due to the quickness in which the incident took place and the suspect attacking him from behind. He advised that he would be able to recognize the subject if he were to see him in
Now,
person.
is the full robbery shown on the video?
It says. Have a moment from the court. It says here on page 3 of 4 of the of the affidavit, Your Honor, that the victim then enters the camera's view and kneels down at the corner of Northwest 10th Court and Northwest 47th Avenue. The victim looks as though he's tying his shoe. The suspect returns in camera view as well. Walking up behind the kneeling victim, the suspect pulls an object out of his waistband.
Okay. So the whole
Then it says at
the
5.
whole event is on video.
Yes.
The individual says from the video, she cannot identify him for sure, but another police officer from watching the video of the entire event says that is Mr. Johnson. Is that correct?
That is incorrect, Your Honor, because it says that you're saying that the victim watched the video. It says that the victim was unable to identify the suspect from a photo lineup, not from the video.
So they never showed her the video.
I am not sure, Your Honor.
Okay. So the identification is by a police officer who saw the video.
Yes.
Okay. The court doesn't find the proof evident presumption great as to the offense. The court sets bond in the amount of $50,000, no contact, and if the defendant posts bond, he will be on a electronic monitor. Level 1. Okay, Devante Moss. Mr. Moss, you're charged with sale and delivery of cocaine, 3 counts, $10,000 bond. Then you're charged with robbery, and counts 4, 5, 6, 7, and 8. And that's with the firearm. State?
Honor, on this case, I'm relying on the 4 corners of the probable cause affidavit. In this case, Your Honor, that all victims were able to identify the defendant as the suspect, Your Honor.
And what are you asking for me to find?
Find proof evident presumption great and
Thank you.
hold the defendant no
Defense.
bond.
The facts are different in this case, Your Honor. We'll reserve argumentation for division.
Excuse me?
We'll make argument in division. But based on the facts in this one, we'll make arguments in
I
division.
understand.
It is still
Okay, the
within
court-
your Honor's discretion to set bond.
The court finds proof evident presumption great. There will be no bond hold on counts 4 through 8.
And can I ask
Okay.
for no victim contact, Your Honor?
No victim contact. Have a good day. Okay, now we go to Clement Charles Plummer. Mr. Plummer, you're charged with possession of a weapon or ammo by a convicted felon, possession of a weapon or ammo by a convicted felon, and it's the same charge on counts 2 through 20. Court finds probable cause, all counts. State, anything?
Judge, we would ask for $10,000 on each count.
How much?
$10,000 on each count.
Okay.
Judge, given that they're charging each bullet individually, I would just ask for bond on count 1 for the gun itself, and then maybe for one of the bullet charges, and then the BR award on the rest, however Your Honor wants to do that.
Anything else, State?
No, Judge.
Okay. Court sets bond in the amount of $5,000 on count 1. Court sets bond the amount of $3,000 on count 2. court RORs the defendant on the remaining counts. It was one weapon with one magazine, and all of the bullets were contained in the one magazine. Have a good day, sir. Franklin Roos. You're charged with possession with intent to deliver marijuana, $1,000 bond, resisting an officer without violence, no bond required. $1,000 bond. Can you make the $1,000 bond?
Yes, sir.
Okay, post a bond. Get out of there. Okay, Michael Oleano. You're charged with petty theft, and then count 2, giving false information to a police officer. Okay, which is on this case is a third-degree felony. Bond is set in the amount of $1,000. You also have a drug possession or charge or paraphernalia charge with a $2,000 bond out of Osceola County. So you would need a $3,000 bond to get out. Have a good day, sir. Now we have Samuel Florinord. You have trafficking, sir, in hydrocodone, the 4 grams less than 14 grams, more than, and possession of cannabis. Bond is set in the amount of $75,000. Court finds on count 1, court finds probable cause. No bond is required on count 2. Then we have Christopher Crawford. This is an ad charge on Crawford.
Change of charge, Judge. It was originally occupied dwelling. It's been changed to occupied structure.
Was there a bond set in the email? What was the bond? 25,000? Judge, it's just a change of charge. I'm asking for the same amount of bond.
Okay, the bond, what was the bond? On this count? Okay. Court finds probable cause, $25,000 bond, which was the original bond set. Okay. Thank you very much, sir. Then we have Derek Jean Pierre. This is an ad charge also.
It's an ad charge or change of charge?
Change of charge.
What was the original bond?
What's that?
It's a change of charge. And here's the corrected,
What's the change of charge to?
it was supposed to be without violence, so it should have been with violence. So it was actually, they had to correct it from, without to with violence.
So it's with or without? Which one do we got?
With.
With, okay. Bond is set in the amount of $1,000. Have a good day, sir.
Just 2 things. Mr. John Pierre, step back. I'm acting as a friend of the court simply because he, on the case, has private attorney Weinstein on the case. However, I notice when I'm looking at this, he's being held no bond on a bondable offense. It's not before us today.
Not this charge, I just said.
No, not this charge. It's a different charge. This is count 10, but he's being held no bond on Agbat Leo, which is not a punishable by life case, and I'm just wanting the court know of that situation. Like I said, his private attorney
But
Weinstein.
I don't have that in front of me. I
know,
believe somebody else ruled on it.
I'm just wanting everybody that I just have to
Okay.
see it.
So noted for the record. Mosey Cruz.
Conti facility, Your Honor.
Good morning, Judge.
Conti, okay.
Good morning, Judge.
Good morning. You're charged with robbery with a firearm.
No firearms.
Firearm.
Judge, it was a change of charge from robbery with a weapon to robbery no weapon.
No weapon, okay. Okay. Okay, and then there's, the petty theft, right?
Yes, Judge.
Okay. State, you want to be heard on the bond since it's a bondable offense?
Judge, I believe that on the initial charge that he came in with, the robbery with a weapon, Your Honor gave him a $2,500 bond. So I guess we would be asking for the same bond amount.
Judge, since this is a down file, I would ask for a change in the bond amount. So originally, he came through on a first-degree felony, the robbery with a weapon, which is now just robbery without a weapon. And originally, it was a robbery snatching, now it's a petty theft. And so I'd ask Your Honor to consider lowering the bond. He's been in custody since May 19th. He's unable to afford any bond. I'm asking Your Honor to consider some sort of non-monetary conditions, even with some sort of electronic monitoring. But he's been in custody on this probably for about 50 days. And now
Okay, and let me get this. This is, the bond was set at $2,500
on each
on the
count.
original charge.
Right, so 5,000 in total. And he's been in on that for about 50 days. I'm asking Your Honor if you would consider some sort of non-monetary release given the down files.
State?
Judge, we would ask that you keep the original bond amounts on both counts.
How much was the bond on two?
It was 25 on both of them originally set.
Okay. Bond is set in the amount of 2,500 on count one and $750 on count two. Counsel, the defendant doesn't have a residence.
I have an address.
You have an address now?
Yes, sir. Yes, sir.
Okay. Pre-trial release with a monitor,
Thank you, Judge.
level 2. Michael LaPellette?
Yes, how you doing, Your Honor? North Broward.
All right, sir, you're charged with exposure, $100 bond, disorderly conduct, $25 bond, and then you got a violation of probation. You're set to go before the judge. Can't do that on the 28th of June. That was yesterday. Did he go?
Yeah, they reset it for Tuesday the 2nd.
They reset it for Tuesday, so.
It's reset.
Judge, I was in court in Judge Usan. They didn't have any BOP paperwork there yesterday.
We're hearing the other public defender, who I'm guessing.
Yeah, this is called pass it back and forth. He's reset for the 2nd or the 1st? I want to make sure he's reset for someday, because this is how somebody can get lost.
On the court system, it shows that he'll have his VOP hearing, his first VOP hearing on Tuesday.
Tuesday?
Yep.
All right, sir.
Can I ask you real quick, is that what the VOP was for these charges? That's what I'm violated for?
Sir, I don't know what the violations are entirely. I don't have that material in front of me, but bottom line is, you've got a hearing on the 2nd, all right? And I'm noting it on the record.
What I could tell you, Mr. Whippo, I do not see any warrant that was out for you before these charges, so I'm.
Okay, have a good day.
Aye.
Court finds probable cause. Travis Young.
Medical loan.
Okay, Now we have Ronnie Hervin.
Mr. Irvin refused.
He's
Your
what?
Honor. He refused, Your Honor.
He refused?
Yes, sir.
All right, reset him to tomorrow. If he refuses tomorrow, we'll address it. Okay. Then we have Norberto Lopez.
Yes, sir. North Broward.
Possession of cocaine, driving while license suspended. Bond is set $1,750. Can you make that bond?
No, not really.
Okay, the court will place him on pretrial release, special condition of pretrial release. You have to have a drug evaluation and treatment if it's required. You agree to that?
Yes, sir.
Pretrial release with successful conditions.
Yeah, so we got to report to him. Okay.
Well, let's see what. I still leave it as that. Yorick Scott.
Oh,
Have a seat, sir.
Hang on. We got Arthur Damon. Is that you, sir?
Yes, Judge. Yes, Judge. Good morning.
You got a criminal mischief, $500 bond. Okay. Court finds probable cause bonds set in the amount of $500. Can you make the bond?
No.
Okay. Pre-trial release. Have a good day. Yorick?
Your Honor, he lives outside of the Tri-County area.
That's all right. Pre-trial release on him, anyway. Yorick Scott.
He would send it to the case file.
Anybody got Scott?
Medical loan.
Paul Ryan?
No, medical loan.
Medical loan? All right, then we have Richard Sergalis, yes. You got him?
Yes, only as to the municipal city ordinance. I believe he has a violation of pretrial warrant. That's no bond.
It's at main jail, Your Honor.
Okay, Mr. Sergalis, we have a warrant for VOP, no bond hold. You have a municipal ordinance, $25. Court will ROR him on the solicitation. Sir, you'll be detained going before the felony judge. When's the date?
It's a violation of pretrial release, Your Honor. He's not going to be in any rush to be put on the docket.
Well, I've got a VOP. Oh, no, it's pretrial release felony. What's the warrant on that?
Stated.
I've got,
He never reported to pretrial. A petty theft charge.
all right. Mr. Sorrells, if I put you on pretrial release, you gotta show up. If you don't show up, you're gonna end up with another no bond hold, sitting in jail for months. You understand?
I do, that's not gonna happen, I appreciate that.
All right, pretrial release on the whole thing. Then we have Kenneth Daniels,
Medical loan.
medical loan, pretrial release on everything. All right, I believe that concludes the docket.
Judge, we had one of the families come back from earlier.
Page 2.
It was page 2, Judge, Rania Sadoon, but they wanted to address the court.
I wanted to know if we could get pretrial release because we can't bond her out today.
All right, pretrial release with a monitor, but level 2. Okay?
Thank you.
She's gonna have to wear a monitor. She's gotta obey the rules.
She won't be out today?
She out
She be
today.
out.
Once they clear her and we receive the file, that could be tomorrow or it could be Monday.
Then no monitor. Okay.
Could I,
2 through 5.
could I say something, sir?
Your Honor, on count 2 through 5, since there's no PC on count 1.
Yes, you said no PC on count 1 RR and contact permitted, so 2 through 5? Or you wanna?
Pretrial.
Pretrial on all of them? Or
Pretrial on everything that, so we don't have anything coming back.
Okay. All of them.
Thank you. All right, that does it. Very good job by everybody. Thank you very, very much.